Yes, Mr. Sims.
Good afternoon, my lords. My lord, I was moving on to ground 3 to take that next on the basis that I think your lordships would prefer me to do this now.
Yes.
Before I do so, we have dug out, for your lordships' benefits, the statement of administrators' proposals and the other online documentation concerning the notice of move from administration to dissolution. Those contain, certainly the administrative proposals contain a list of creditors, which is broadly similar to what we already looked at. But I think your lordships indicated you'd like to see that.
Yes,
if
there's no objection.
As well. So
as well.
It's probably a convenient moment to do that.
Where shall we find a home for these?
I think probably the best bet would probably be the back of the supplemental bundle if there's space. And we might notionally give them tab references 39 for the statement of proposals and 40 for the second document.
No more additional documents for the supplementary bundle on any account.
I think we were already outside our permission, I think, probably
yes.
for page count already. The two brief points I think you just wanted me to pick up on was, I think, to do with confirmation of a bank appointment. And you see that in the statement of proposals at paragraph 2.5. If looking at the internal pagination, it's page 2. Continuous pagination. And then, so far as the position in relation to creditors, we see that internal pagination 14, which is an annex to the statement of proposals, which contains the statement of affairs. And you can say, under the heading Summary of Liabilities on page 14, 2/3 of the way down the page, there's a reference to unsecured non-preferential claims. Can you see that? So page 14, Appendix D, Summary of Liabilities.
Yes.
After the fixed charge, yeah.
Debts to the bank is 16 million.
The debt secured by floating charge after the fixed charge. I think that there may have been a distinction there between the fixed charge and the floating charge. But I think the information you were interested in was the list of unsecured creditors, which you can see there.
I'd quite like to know how much was owed to the bank.
Sorry?
I'd quite like to know how much was owed to
well,
the bank.
I think what was owed to the bank was, I think, 36 million in total. And I think they were paid in the region of 24 million by way of realisations. But there was a mixture of fixed and floating charges. So quite where that would have fallen within the statutory scheme.
Yeah, it says the bank was owed approximately 36 million before interest and charges. That's paragraph 10.10.
Yes.
10.1, sorry, of the report.
Yes. I'm grateful.
So the sums due to the Rileys and to the other unsecured creditors were a pretty small proportion of the overall indebtedness of the bank.
The bank was obviously by far the largest, yes. 3 million, I think, is the suggestion, isn't there, in that, and that's 3.5 million. Yeah. And the principal focus, obviously, in this case, would have been on realisations, when the bank was obviously the primary beneficiary, primary interested party in that.
Yeah, you can see that the bank's actual amount is at page 15, 35,853,533.
Yes. I'm grateful, and that also contains the same list of breakdown in relation to the creditors too. So Clegg Construction, Mr. and Mrs. Riley, and we can also see the breakdown in relation to intercompany account there with NDA Nottingham, and then some other smaller creditors. I think that was probably the main document we wanted, but for completeness, we've also given you the back end document of the administrators, which is the second document handed up at tab 40, which indicates the move from administration to dissolution, and just deals with various different events during the course of the administration in terms of the realisations, investigations, etc. And obviously records at the end that the intention is to exit via a dissolution, the company having no property to permit a distribution to unsecured creditors. And you see that's the sort of conclusion, if you like, of what happens next at page 8.
It seems the bank's been paid about 24.3 million out of 36 million owed at the start of the administration.
Yes. That's right, you can see that from page 2.
Yeah.
And what else? I was now going to move on to ground 3. And well, also obviously ground 3 is that the judge erred in concluding that the appellants did not have a real prospect of success in establishing at trial that the release clause in the settlement deed should have been construed as not including the fraud claims which they now seek to bring in these proceedings. And our written argument in this respect is set out in paragraphs 66 to 76 of our skeleton, and to the extent necessary, obviously, we rely on that and seek to briefly amplify them in the submissions now. Well, also, if I can summarise, I think there are 2 strands to our submission in this respect. The first strand is if we go back to the clause itself in question, clause 7, at page 275 of the core bundle, that the clause where it refers to whether or not presently known to the parties should be construed as a reference to the claims being unknown to the parties, plural, as stated. It should not be construed to cover the situation where there is a fraud unknown to the releasor, but known to the beneficiary of the releasee. And objectively, the courts do and should adopt the position, whether it's treated as reflective of the cautionary principle or otherwise, treat parties on the basis that there's certainly an initial presumption in favour of honesty, and that commercial parties contemplate and expect honesty of each other. And frankly, it's dishonest to encourage a counterparty to unknowingly give up a claim based on an unknown fraud without very clear words to that effect. In the words of the Vice-Chancellor in the Court of Appeal in BCCI and Ali, it is to reward dishonesty at the expense of the innocent. Now, of course, the House of Lords differed in their approach to that of the Court of Appeal, in the sense that they concluded that the stigma claim, in fact, in law was not known. That's not obviously a distinction which applies here. But in our respect for submission, the approach taken, which you can see by the Vice-Chancellor in BCCI and Ali in the Court of Appeal, is reflective of whether or not you call it the cautionary principle or a presumption in favour of honest dealings, that it would be an unusual situation to expect a party to knowingly agree to a bargain whereby they're signing up to a deal where they're agreeing to give up a claim in fraud which is unknown to them but known to the beneficiary of the release.
Can I just try and put this into some sort of legal context?
Yes.
You say it's sort of dishonest to encourage the other party to give up a claim which the one party knows and knows the other doesn't know. So what is this, an aid to interpretation or a setting aside of the agreement, or what's the framework? Is this...
This is a construction argument. So it's an aid to interpretation of the agreement.
So you assume that both parties are not dishonest and therefore they couldn't have intended that.
That's right.
Well, you start on the basis that the court will normally presume that when parties are entering into an agreement, a settlement agreement being no different, that they will act honestly. That is the way that commercial dealings work in life. Now, of course, I have to accept that there may be circumstances in which the wording of the agreement or the clause in question shows that the bargain struck was, I am giving up a claim in fraud which is unknown to me, even if you know about it. So I'm not saying it's a conceptual impossibility.
When you say dishonest in relation to an organisation like the bank, how can we apply this? Because the deal was presumably negotiated at one level, and such the knowledge of the facts that would give rise to the claims of the type you're talking about is somewhere else in the bank. I mean, when you're talking about dishonesty, what human mind are you asking us to identify, or are you falling into the old trap of saying, well, I can add together a number of different minds in a corporate organisation and conclude that the corporate was dishonest? I'm just struggling at the moment to put this into the context of this agreement.
No. Well, I can understand the point your Lordship is making, which is there may be in a large organisation, there may be a question, a factual question which might arise as regards whose state of mind is relevant for the purposes of assessing construction and sharp practice, in fact. But the assumed facts upon which the judge disposed of the case against my client at first instance was a plea that the bank knew of the potential for the Rileys and RHL to make a claim of the type now advanced, and also knew of its impact.
But who? I mean, that's just pregnant with a request for further.
I accept that, and I accept that a request could be made. It hasn't been made, and the judge dealt with on an unexplored basis, if I can put it that way.
Yeah, but I mean, in a sense, we're not bound by that. I mean, in a sense, if you're putting to us a proposition that we must approach the interpretation of this agreement, or this agreement must be approached on the footing that we must assume an honest state of mind on the part of the person negotiating it, or the bank. I mean, I'm just trying to drill down to what
the way I put it slightly differently, that the law will generally presume, as a matter of commercial dealings, that parties engaging in contractual discussions act honestly. The question of the plea that the bank knew of of the potential for the Rileys to make the claim which they're now making engages a separate question in relation to whose state of mind is relevant for the purposes of that plea. And I can see an argument for saying, well, further and better particulars and so on and so forth. But the judge, at first instance, approached the question of construction, making that assumption that the bank knew of the potential for the Rileys and RHL to make a claim of the type now advanced in the proceedings, and also knew they were ignorant of its existence. So that plea was specifically put in issue by us, and was the basis upon which the judge at first instance approached the construction question. And so in those circumstances, in our respectful submission, the question of whose state of mind is potentially relevant for these purposes is to be explored. It's not been explored on the pleadings, and it's not been dealt with. It may be another reason why these sorts of cases are not best dealt with on the basis of assumed facts, but actually at trial.
Where do we find the assumed facts?
First of all, the plea that we made in our plea is in the reply, page 261. So it's in document 10.
Did the judge make any findings, or did the judge record what were assumed facts?
Yes, I think I'm just checking as to whether or not this was in grounds 1 or 2. Let me just see if I can briefly find in the judgment. Yes, he does make this. He does record it in his judgment. Just give me a few moments, and I'll ask my junior to look for us as well. But the first part, in the context of construction, is in paragraph 69 of the judgment.
But that only goes part of the way.
Well, if we also look at paragraph 2 as well.
Paragraph 2.
Yes, where the the whole application proceeded on the basis that the bank accepted that the pleaded allegations of the claimants were correct. That's the basis upon which they were pursued. I think there is another passage which my learned junior is hopefully looking for.
That paragraph 69 that you showed us again doesn't make the point you're now making.
I think it may be partly because it's in the context of construction.
You're basically saying it would have been dishonest for the bank to have put forward an agreement which invited the Rileys to give up a claim in fraud of which the bank knew that they were unaware. The bank wasn't dishonest, ergo the agreement couldn't have meant what the bank now says it meant. That's your line of logic.
So our line of logic is that as a matter of construction, that the court should not interpret the reference to giving up of claims unknown to the parties as the giving up of a claim which is unknown to one party but not the other, in circumstances where the other knows of the potential claim.
It's right at that last bit where you say in circumstances at which the other knows, and I'm searching for either the factual basis for that assertion of knowledge on the part of the bank, which I would say has to include knowledge on the part of somebody, because the bank isn't you have to attribute
the plea which we made in our reply made that plea of that fact.
That paragraph 69.
No. In our reply, so paragraph 69 is in the judgment, I think. But the plea.
No, it was that's what you referred us to, wasn't it?
Let me just check. So it's 69 in the judgment.
Sorry, I've got the wrong paragraph.
And then the reply.
79.
79. Sorry.
79. I'm afraid. At page 261.
All you plead is that they knew of the potential for the Rileys to make a claim. That's enough, is it?
Yes.
And I mean, you don't identify who on behalf of the bank knew.
No, that was not explored because the bank just proceeded to their summary judgment or strikeout application without serving the request or any of those sorts of things.
And then you say it would be sharp practice and unconscionable, which appears not to be aimed at interpretation at all.
No, I accept that plea is primarily directed at the question of sharp practice, but the point that I'm making here is to approach the question of sharp practice as a matter of construction. So, in other words, if the court were to conclude that objectively speaking, the court would not interpret the release under clause 7.1 to extend to the situation that the parties did not in fact objectively intend unknown to the parties to be one-sided, a fortiori in circumstances where the other party knows of the fraud, then that's a question of construction as much as it is as feeding into the sharp practice principle. Because the question which hasn't been addressed head on is, if you posed the question to the Rileys at the time, or indeed the bank at the time, did you contemplate that this would be dealing with a situation where the claim was not unknown to the parties, but unknown to one of you, but known to the other? What would they have said?
I'll ask you this. The fact is the bank didn't expect the claims, it didn't require the claims to be settled. RHL's claims were not compromised.
No.
To the point at which you make great play.
Yeah.
And indeed, that would have been the primary way through which the Rileys would have benefited. be claims by RHL. And in fact, you said to us, your submission this morning was that the real purpose of the agreement was to restructure their personal liabilities, not to release claims. Now, if that's right, it's hard to see how there's any concern about releasing fraud claims or about sharp practice here. Because as you say, RHL retain their claims and they can be brought, if appropriate, by the administrators.
Yes.
Or
But, so
third
this is all standing separately from the RHL, the ground 5 arguments. But I accept that point that there is still a residual personal claim, which stands separate from the RHL.
But what is the residual personal claim?
That they, as employees of RHL, have suffered loss of earnings, that they caused assets to be transferred into the company, which may or may not, depending on where you end up in terms of an assessment of the calculation of RHL's claim, result in monies coming back to them as creditors.
That's almost certainly going to be caught by reflective loss,
I don't think.
if RHL is made whole.
I think the reflective loss principle is restricted to as reflective as shareholders. I think is
Not sure that's right.
under merits.
I think it extends. Isn't there the Privy Council case after that?
I thought that they had. I thought the current state of the law, but is that creditors are not included.
That was my recollection.
But I'm not claiming to be up to date with the law in that respect.
My understanding is that in fact, previously a Court of Appeal case had suggested that creditors was caught, and Marix, I think, restricted it to reflective loss based on the shareholder position.
We're getting. And I'm saying you haven't brought these authorities because this is. At the end of the day, the point is this: when we come to look at this, we have to, and the idea that this is the bank is acting sharply here, we have to have in mind that your clients were pressing them hard to settle, and indeed were chasing them mercilessly, actually, to do the deal. And at the end of the day, you rightly say the bank didn't even insist that the main claims were settled. So all they said is, well, yes, okay, we'll reduce your debt to 1.1 million and give you 15 years to pay, provided you don't sue us, not RHL.
No.
Well, that puts a big hole in both the interpretation argument and in the sharp practice argument, doesn't it?
I'm not sure if I completely follow in the sense that I can see the argument that if we succeed on ground 5, we did, obviously the principal claim is the RHL claim. That's the £70 million.
Whether you should, but even if you don't succeed on ground 5, it's still the case that the bank did not require the RHL claims to be released.
No. Yes.
I mean, it's a different matter whether the bank required that Mr. Riley.
I think that may then feed into a question of: is it likely that the bank knew of some other claim which you didn't know about? Is that the point? Maybe I'm being a bit slow, but I think
your point is that this shouldn't be interpreted as the bank deal here being that the Rileys would give up their future claims in fraud. But surely factoring into the fact that the bank didn't require the primary claimant, RHL, to give up its claims in fraud. All it said is if you, Mr. and Mrs. Riley, are going to have your debt reduced from 2.7 to 1.1 and be given 15 years to pay, you can't come after us for anything hereafter.
Yes.
RHL can.
Yes. Well, that's the ground 5 argument.
No, it isn't the ground 5 argument. It really isn't. Forgive me.
Well, I'm struggling to understand. My point was a fairly narrow one, which is that if you look at the Vice Chancellor's speech in BCCI now,
Yes.
Albeit the House Lords took a different approach subsequently, he approached it on the basis of, you would ordinarily expect parties to engage in settlement contracts honestly, and therefore, as a matter of construction, I'm not going to construe this contract as capturing claims unknown to one side, which are known to the other. So he approached it in paragraph 30 as a matter of construction. And in my respectful submission, that point has not really been explored in the case law in the context of construction, as opposed to sharp practice. It is explored in the context of sharp practice.
But it was explored in Satyam, wasn't it?
In Satyam, the same point, isn't it? Paragraph 84, where the judge poses that question. So I'm not sure if I'm just being thick, but I think the fact that the bank didn't insist on parties of any deal they struck with the Rileys, that in some way RHL should be joined in and somehow bound into all this. I personally don't quite follow your Lordship's reasoning as to why that has an impact on ground 3, but maybe I'm being slow.
Well, because, as I understand it, what you're saying, your case is that one should construe this clause as not preventing Mr. and Mrs. Briley from bringing claims in fraud.
Yes.
Because that would be, but surely relevant to that as to what the bank was doing is the fact that the primary case in fraud was that of RHL.
I see the point.
And they weren't
requiring
stopping RHL from bringing a claim in fraud.
Yes. No.
All they were saying is, if you lose on ground 5, all they were saying is Mr. Riley can't sue us for RHL's claims in fraud.
No, I think I understand the point your Lordship may be getting at, which is if we approach this settlement deed on the basis that it doesn't include RHL claims,
it definitely doesn't.
Yes, then
RHL's not a party.
No, RHL's not a party. Then why should objectively the Rileys be taken as giving up this other claim as well? I think that's your Lordship's point.
No, my point is why would one construe this as the bank doesn't mean what the agreement doesn't mean what it says, that all agreements are or all claims are excluded by the Rileys, when that leaves the claims which you say the bank knows about, which is RHL's fraud claims.
Well, I think that the specific...
the bank would have to be looking at this pretty widely to be thinking about, well, because of what we did to RHL, Mr. and Mrs. Riley would have claims. I mean, that's a whole different... And even in your paragraph 79, you say the potential for the Rileys and RHL to make a claim of the type now advanced. Well, I think the bank, at the highest I thought you can put it, is they knew the potential for the RHL to make a claim. Would the bank have known about the potential for shareholders and employees to make a claim from that? I think that's taking it quite a long way.
Well, also, I'm approaching my mid-afternoon
Sorry.
slot where
probably...
Yes, you are.
and I think all I'd say is this: is that the specific point that the first point we were seeking to make under ground 3 is to deal with a point which I don't think the authorities have yet so far really grappled with, which is when one is dealing with a wide clause which refers to settlement of claims known or unknown by the parties. Is there a difference in that scenario between known or unknown to the parties in combination, or just to one side? That's the real point I was trying to get at, and I leave that with your Lordships, obviously, as to whether you think that's a valid.
Maranello is dead against it.
Sorry?
Maranello is dead against it.
Maranello is a very different case in this sense, isn't it? That Maranello was a case where it was in effect the same causes of action that were being...
No, that's the whole point. They weren't the same.
Well,
causes of action,
no, originally it was, and then they just said, well, this is in combination.
which is a different cause of action.
It's a different
It's a
different wrapper, isn't it? But I mean, combination claims, obviously, conspiracy claims.
Well, they found out further facts, which they said meant that there was a conspiracy against them.
They refer to a meeting where they suggested that they'd identified a malmotive, if I can put it that way, but they relied on the same causes of action principally in relation to what made up the conduct in question. Here it's very different. What the Rileys were really focusing on back with Navarro was in some way there's been some attempts to artificially distress our businesses and wrongly putting them in administration. Whereas in actual fact, post the promontory report, it's the internal designation by you of us meant that you actually intended to exit the relationship rather than supporting the return to mainstream as you promised to us. And if we'd known that, we would have taken different course of action, both personally and obviously on behalf of RHL. And it's that which gives rise to the loss in this case, on the basis of the counterfactual lens scenario. It's not like in Maranello, where there was almost like an attempt to sidestep the wide clause on the basis of pleading a conspiracy or combination with the same causes of action underlying it. Our reading of Maranello was that the court made the finding at first instance in the Court of Appeal the very same facts. Aside from obviously this allegation about this meeting and motives, but here it's not the very same facts. The plea of the cause of action here is very different. The plea is, at its heart, you made representations to us which were untrue, which were false and known to you to be false by reference to your internal designation, your own records, and which your employees knew about.
Can we take Lord Justice Phillips's summary of the effect of the case law to date in Maranello as being correct? It seems to me a pretty useful back catalogue of sort of greatest hits from the reported cases in the Court of Appeal, House of Lords, of Supreme Court, up to the end of 2022.
I didn't detect any significant error or argument that we have in relation to the statement of law in relation to Maranello. Our point was more to do with in Maranello, was to do with it was very different. I think
I wasn't sure you were necessarily accepting what I said about Satyam in Maranello.
Well, maybe we should just focus on that. I mean, what I think what we're saying in relation to Satyam is that the Satyam question, I think it's paragraph 84 probably is in Satyam.
Well, you and my lord may know the cases by heart and know what paragraph 84 said, but speaking for myself, I don't. 84 of Satyam?
Yes, so if we go to Satyam, then my lord, my apologies, it's behind tab 14, which I think is in the second file. And the particular passages which I think are key are at page 581 of the continuous pagination, 482 of the report. It's really key passages 82 to 85.
Right. And what did my lord say about that in Maranello?
Well, I think that the discussion section in relation to construction on Maranello is in my lord's judgment behind tab 31, which I'm guessing maybe it might be file 3. I think the passage in the judgment where Satyam is referred to may arise a little bit earlier. So, for example, I think the first reference to Satyam by my lord Maranello probably is at page 1282 of the continuous pagination, or page 17 of the internal report, paragraph 43. So I didn't understand paragraph 44 to be a departure from
I thought you were relying on Satyam to put forward a rather stronger principle than I think I had understood, than I was recognising here, about whether or not parties can settle claims in fraud.
Well, we certainly rely on the passages in Satyam I took your lordship to, and say that as applied, so in other words, if one poses the question recognised in Satyam of if you put the question to the person who's giving the release at the time, do you recognise that this would be a release of claims, unknown claims in fraud by you? That put that way, that the proposition is a clear no. A criticism we make of the judge's reasoning and approach is that he appears to have treated Maranello as his yardstick to apply, when in fact Maranello was a very different case. Maranello was a case where there were findings by the judge at first instance and on appeal of I think that the words used are the very same facts. So we did not interpret Maranello as covering the different situation where this case falls into the category of not the very same facts, but nevertheless a context of claims being made, which, as the judge said, potentially could involve allegations of deliberate wrongdoing. And so, in our respectful submission, it is a different category of case from Maranello, and the judge was wrong to treat it as simply the same. We say that it is a healthy question for the court to pose an answer as a question of construction as to what the releaseor would have said at the time contemporaneously, because it's inviting the court to pose that question by reference to the very claim that they are now pursuing, so a claim which they didn't know of at the time, which they're now pursuing. Would, as at that date, they have contemplated that the release would in fact have covered that unknown claim in fraudulent misrepresentation? That is ultimately the inquiry which...
I wonder how useful that question is, because if you ask the releaseor expressly, are you releasing claims in fraud, you might get one answer. If you ask the releasee, you get the other answer. And fact of the matter is that at the end of the day, you have to read what their agreement is to work out what they did in fact agree. And postulating that one or other of them may have not liked the consequences of their agreement, if they'd realised what in the real world that would amount to. I'm not sure that's very helpful.
Well, look, maybe that is the difference conceptually between the approach you've identified in Satyam, because quite clearly in paragraphs, I think it's 84, 85, that is the way it's put by the Court of Appeal in Satyam. And in my submission, that is not ignoring the objective basis for construction. It is simply asking the objective question by reference to the fact that this is a one-sided release. It's not a mutual release. It's a one-sided release. And you're asking the question of what is in the reasonable contemplation of the person who's giving the release.
Well, we've seen from the authorities that it is quite clear that it is possible for the parties to agree to release unknown claims and fraud. But as it's Lord Collins, isn't it? Lord Justice Collins said, if a party seeking release asked the other party to confirm that it would apply to claims based on fraud, it would not in most cases be difficult to anticipate the answer. My part, I'm not sure where that takes you.
Well, I think the reason why the Court of Appeal is posing that question is because it's asking the reviewing court after the event to put itself in the shoes of the releasor and ask objectively, was that part of the intended bargain as at that time? And I recognise the point your Lordship's making, which is, well, there's a tension between what a party wants and what it gets. But the question is not posed at what it wants, but what it gets. The question is posed at, objectively speaking, on the ground as at that time. Does the court think that the Rileys, if they were posed that question objectively, do you recognise that this covers an unknown claim in fraudulent misrepresentation based on the bank having designated you internally as this, and actually this is what they told you? We would say that the ripostat is clearly not.
Well, I don't know. I wonder, that time when they were having the reduction in their liability from 2.7 to 1.1, saving their home and getting, I suspect they would have agreed to a lot of things.
Well, my Lord, that is a different question. I think that they would agree to a lot of things. But I think the question is...
They were the ones who wanted this agreement.
Well, I think both parties clearly wanted the agreement and got things out of it. The bank got its improved security, etc.
The bank's not going to do an agreement, make an agreement it doesn't want.
No. So the both parties wanted the agreement. I'm not cavilling at that, but I think your Lordship's response, if I may say so, is, well, I don't know, is perhaps... Well,
that's why you say it has to go to a 10 or 20-day trial in the commercial court with all the witnesses being called and people asked about it. Yeah.
Well, I'm not disputing the fact that frequently the courts do deal with construction issues somewhere. Clearly, it's appropriate. If the matter is going to go to trial in any event, that's the reality. Then that may also be a compelling reason, because if you do entertain doubt as to whether or not the Rileys would truly have intended, did truly intend at the time that
but that would be investigating their subjective intention, which we can't do.
No. I'm not suggesting for the purposes of the construction that but clearly the trial court would have a lot more information about the contextual factors which may have a bearing on objectively if that question was posed.
But you accepted before the judge that this was a question of construction.
Subject to the sharp practice point.
Yes.
We didn't.
Sorry, and suitable for summary judgment, I think. Summary determination.
I don't. We certainly didn't encourage summary determination. We didn't reject the notion that construction cases may be readily dealt with as a matter of interpretation. We would respectfully submit that point should be determined in our favour summarily. But I think the point is, it's not an easy point. It's not a straightforward point. How do you assess objectively what the parties intended in relation to an unknown claim in fraud as at that time, which is not an easy exercise, and it may well be informed by a further consideration of all much more detailed factual evidence that we laid before.
Well, there's a big difference between a fraud and a claim in fraud and a potential claim in fraud. And a party, it's one thing for a party to give up, to absolve a party of an undoubtedly established fraud, and it may be one other thing to give up a good claim in fraud, but another thing altogether to give up a potential claim in fraud.
Well, then doesn't that highlight why particularly these principles are best determined when we have a bedrock of established fact?
But that would mean that almost every one of these cases would go to trial, and that would completely undermine the commercial sense and efficacy of settlement agreements. It would remove certainty, which is so desirable.
Well, that certainty could have been achieved by spelling it out. So the certainty could have been achieved by the bank saying, this settles any claim which is unknown to you in fraud, even if it's alleged we know about it. There are ways of covering these things off as a matter of construction if you want to spell them out, which weren't. And you do see other clauses where they are drafted that way. We're not saying commercially English law does not allow that.
Can I ask you about this, Mr. Sims? It seems to your claim in fraud is saying that your clients didn't know about the core and non-core business differentiation, that meant that the representations made by bank employees to the Rileys were dishonest, fraudulent, deceitful, and therefore they can sue for fraudulent misrepresentation.
Yes.
But the Nabarro's letters, which we were shown, made many allegations of dishonest behaviour, not exactly that one. And is that relevant?
Well, in my submission, I would have to accept that if your lordships took the view that the correspondence was alleging dishonesty against the bank, it has some relevance for the question of interpretation of the settlement deed, because in those circumstances you can see objectively why the bank may say, well, this is part of the bargain, you're giving up these claims. The judge didn't go that far himself. The judge, I don't think anyone suggested that there was actually an allegation of fraud or dishonesty in the sense of fraudulent misrepresentation.
Mr. Sinclair's skeleton says that there was.
Well, I'll let him develop that, but I didn't understand that to be the judge's conclusion. I think the judge.
I must have misunderstood. I thought he was saying that you had accepted that there was an allegation of dishonesty.
I think he was referring to my paragraph 70, where I think I was dealing with the judge's.
That's the judge's paragraph 70. The reference in the Nabarro correspondence to a thinly disguised ploy by RBS NatWest to take onto its books an incredibly profit asset at a cut price for the benefit of West Register, and contrary to the interests of RHL and the claimant.
But what is the cause of action? It's pejorative language.
Deceit. Isn't it?
Well, I don't know if it is. I don't think you can necessarily say. I mean, they express the concern about that, but they don't say we are advancing a claim that you have made a dishonest misrepresentation, identify what it is, etc.
I mean, the problem of these questions, this debate is highlighting that, in a sense, context is all, because if you look, for example, at BCCI, you have there a clause which is simply inserted in a termination of employment agreement, held not to apply to a fraud which the bank had been, the fraudulent way in which the bank had been conducting its business, its entire business, in fact, BCCI pretty much,
yes,
4 years, to its knowledge and to the ignorance of the entire world. if you have a situation in which, for example, I think was the case in Satyam, that the parties have come to loggerheads about a services agreement, I think it was in Satyam.
Yes.
And the question is, yes, but is that intended then to release a claim based upon the fact that one of the parties has been forging documents during the course of their arrangement? You can sort of come to the hypothetical reasonable observer looking at what both parties know might well think that they didn't intend to release claims of that very different type, given the dispute which they were actually settling. Here, to pick up on Laura's point, I mean, you've got some pretty forceful correspondence being asserted on behalf of Mr. and Mrs. Riley, but very forceful. It may not use the word dishonest in terms, but I think it says pretty much everything else, and you don't have to read too closely between the lines to see that's what's being suggested. So, in general terms, about the behaviour of the bank. Well, whether it's specifically this type of dishonesty or that type of dishonesty, this type of sharp practice or that type of sharp practice, the bank certainly would want shot of any problems arising out of this situation. Could well be one response that the objective bystander would get.
There's a tension, isn't there? There's a tension between viewing that as what the bank might want and viewing it from the perspective of the Rileys. They're both relevant parties to an assessment of what objectively this contract is about. And
but the Rileys would know that the objective bystander would see, looking at the words, that the claims which had been enunciated in the Navarro's correspondence, or claims of that type, were being made or were being threatened.
But in my respectful submission, you still have the question then, don't you? Even if you view that language as hinting at or raising concerns about
in lawyerly language,
without actually saying the word, isn't there something healthy and cathartic in requiring a party objectively, if they mean business, to actually spell it out? If they truly mean that the objective bargain is to give up a fraudulent misrepresentation claim which is unknown to one party, why is it onerous? Why is it difficult for the bank to spell that out?
But that's neither health nor cathartic effect, nor what a party could spell out, are actually decisive here. The question is, in the context of what was being said by Navarro's in its correspondence, can you say that allegations of the types now put forward weren't encompassed within the very broad words used at the time?
And a response to that is that requires an evaluation of both sides' position vis-a-vis the bargain they struck, and having regard to both sides' position. In our respectful submission, allegations of mistreatment or ploys or whatever, unless it's actually spelled out, why should the Rileys, as the counterparty to that, say, yes, okay, we've made all these sorts of allegations, but we don't know about this cause of action. It may be a very good one.
But forgive me, it's the authorities now clearly established that it can encompass fraud without it being spelled out.
Now, I accept as a matter of context that the trend of the authorities suggests that even if it's not spelled out, the context might support the conclusion that that is covered as well. I accept.
And you've seen Lady Justice Aspin's judgment, which I refer to, very clear authority that widely worded clauses in carefully drafted settlement agreements can cover fraud.
I don't take issue with that proposition of law. It can. But the question.
For very good reason. Which is what the parties are seeking to achieve is finality.
There's the finality policy, and I can see that the parties objectively want to do that. There's also the question of, if the parties don't know about the particular claim, and it is of a different type, which has been expressly articulated, is the fact that there's hints at deliberate wrongdoing or references to it enough? And so we say this.
But isn't that the difference? That, I mean, if you think that the other side, are a party which has behaved dishonourably, disgracefully, dishonestly, in one sense, you know that's the sort of creature you're dealing with. You must understand that if you enter into a full and final settlement, you risk giving up the fact that they may also have misled you, deceived you, and done other things of a similar ilk, because that's the creature you're dealing with. You take the risk when you enter into a full and final settlement agreement. On the other side, a creature of that ilk will want a full and final settlement because it knows it's behaved badly on your assessment of it. So the objective bystander would say, yeah, it's in both sides' interests. One of them because they know they're dealing with a bunch of so-and-sos, and frankly they wouldn't trust them further than they could spit. And the other one, on this hypothesis, knows that it's behaved really badly and it definitely wants out. So why wouldn't the objective bystander say, as my lawyers put it to you, goodness me, you know, these two people deserve to go their separate ways and finality is the key. Whereas some of the other cases are cases where, like Satyam, one side had no idea it was dealing with a party that would forge documents, or the employees in BCC had no idea that they were dealing with a bank that was money laundering and doing goodness knows what.
So I suppose that's the question, isn't it? Does this principle extend in this scenario of obviously Maranello, the spring law letter was expressly referred to as a recital in the agreement. There were all sorts of contextual indicators pointed out. This agreement does not have release at its core commercial heart by reference to the commercial indicators in terms of the background. It looks like it's a settlement involving looking at the means of these particular individuals and some improvement of the security position vis-a-vis the bank and a long period of settlement. And thrashing around in the correspondence as regards potential claims they may have against the bank, which don't seem to have any clear recognition.
Yeah, but the claims are very clear. The claims aren't, you sold me an investment which you didn't give me proper advice on, or it was an inappropriate, you sold me a swap which was inappropriate for my investor profile, or some such breach of regulatory requirements. These were all out allegations of misconduct. No two. I mean, the correspondence, you know, we see.
We're not taking issue with the notion that the judge has.
Thrashing around. They were making some very forceful allegations of misbehaviour, misconduct within the bank that may not have used the word dishonest in a lawyer's letter, but went, you know, everywhere around it.
Well, that's the question, and I think probably ultimately the simple point we would make is that the contextual indicators here, you may say, isn't the Satam end of the territory. It's not at the Maranello end of the territory. Maranello, the very same facts. Here we have a scenario where there's all sorts of generalised allegations interpreted as bad faith, hints that they're concerned about various things. Have they got a potential libel manipulation?
If you think these are hints, I'd be interested to see your full-blown letter.
Well, I think that is the difference we would submit. That in the context of where someone has not actually made the allegation of fraud in plain terms, that actually the court should approach this on the basis that the release is not front and centre of the bargain so far as what's being achieved. It's obviously a standard clause which forms part of the bargain, but it's not a written into the recitals, etc. And it falls into a different category. Therefore, I don't think I can improve on those submissions.
I think we've done construction possibly to death. Shall we go on to the sharp practice?
I'm grateful,
and then I think that
I'm grateful.
We've covered the ground.
Yes. So on grounds 1 to 2, if I can deal with them together.
1 and 2 and a bit of 4.
and a bit of 4.
Yeah.
So I'll try and deal with them as quickly as I can.
Yes.
On grounds 1 and 2, if I just find myself in my notes. So ground 1 is obviously looking at the sharp practice principle, inviting you to conclude the judge was wrong to conclude that summarily against us. Ground 2 is saying, well, actually, is sharp practice a developing area of law? Are the boundaries of it sufficiently well known that actually it's a sensible thing to deal with summarily in any event? And the key parts, actually, of the principle are, I think, probably picked up on in BCCI and Ali in the Court of Appeal, which are then referred to by the House of Lords. And so what I want to do is briefly take you to BCCI and Ali and then look at the passages in the House of Lords. And the short point that we would invite you to conclude is that there are slightly different statements of principle as to how the sharp practice principle should be applied as between the Vice-Chancellor in BCCI and Ali and Lord Justice Chadwick. Both of them seem to get approval by Lord Nichols and Lord Hoffman in the House of Lords, though perhaps without actually unpicking exactly what was being said and whether or not there are any material differences between them. So if I can briefly take you to the passage of the Vice-Chancellor on the sharp practice principle. This is in BCCI Ali behind tab 7.
The judge, I won't stop you if it's essential to look at what the Vice-Chancellor said in BCCI Ali, but the judge, in this case, quotes Lord Nichols, Lord Hoffman, and then Lord Justice Phillips in Maranello.
Yes.
And whatever Maranello decided is binding on us for good or ill. But
I think in Maranello, my recollection of the way the matter was treated in Maranello, well, can I come back to Maranello?
yes, all right.
I will briefly deal with it.
BCCI and Ali.
Yes, if we can look at BCCI and Ali behind tab 7.
Yes.
It's starting off with the judgment of the Vice-Chancellor, the key parts of this speech in relation to, or this judgment in relation to sharp practice is paragraph 33.
Right.
There's a similar statement, I should say, in paragraph 25 also.
This is ignorance by an employee that he had any claim of any description against. Is that right? It's ignorance of the most. It's a circumstance in which the employees were simply on termination, just signed a blanket release. That's what we're looking at.
Well, the release is paragraph 1. It is in full and final settlement of all or any claims, whether under statute, common law, or an equity of whatever nature.
Yes, but it's not in the context. It's a standard form. It's a standard form termination agreement, isn't it?
A standard COT 3 form, yes. And this case didn't have obviously the suggestion that the employees may have known of some wrongdoing, for example, in relation to the facts. I don't know if that's the point your Lordship was making, but can I just deal with the statements of principle and then come back to the application? Because if one looks at the statements of principle in paragraphs 25 and 33, they are, as formulated, the court will not allow a general release to be enforced so as to bar a claim of which the releasor had been unaware. If so, to enforce it would in all the circumstances be unconscionable. So that's the statement as to how it's put by the Vice-Chancellor. If you then just go on and look at Lord Justice Chadwick's formulation, and it's really at paragraph 81. He suggests a statement of principle as follows, where one, the releasee, say A, knows of facts which give rise to a claim, whether or not he believes that claim to be well-founded as a matter of law, in brackets. Two, A deliberately conceals those facts from the release, or say B, in circumstances where A knows or believes that B cannot discover them for himself, and three, B does not know those facts, comma, then A cannot rely on a general release from B as a defence to a claim based on those facts. Notwithstanding that, as a matter of construction, the words of the release would include all unidentified claims.
A cannot rely because it would be unconscionable. I mean, there's a danger always in sort of setting out almost like it's a statute, a proposition.
Well, we would say, applying Lord Justice Chadwick's test as formulated there, that is our case.
Yes. Well, I understand that. All right. Should we go on to the? Do we get anything more from the House of Lords? Because after all, this is, in a sense, all obiter or by the by once the case has come to the House of Lords.
The passages in the House of Lords whereby these passages are referred to with approval by Lord Nichols starts at paragraph, I think it's paragraph 32.
The judge cites Nichols at para 32, Hoffman at paragraph 70, 71.
Yes. I would invite you to look in particular at Lord Hoffman at 70 to 72.
Right.
So, my lords, what we would submit is this, is that the mere fact that objectively construed the party is taken to be submitting to a release of an unknown claim as a matter of construction does not mean that the sharp practice principle has no role to play. The question of what that role, that principle has to play is a fact-sensitive question in each case. If following trial a judge makes a finding of fact that the Riley's claim is correct as a matter of law, that the bank had committed a fraud on them, told them untruths which it knew of, and if the bank also knew that this was in effect, a systematic approach being taken by a number of its employees, and makes a finding the bank knew of those claims or the potential for them at the date of the release, a trial judge may very well consider it's unconscionable in those circumstances for the bank to be able to rely on the release clause.
Yes, I think the difference, certainly that I saw in Maranello, is that it's one thing to say, as in BCC and Allen, that a settlement of unknown claims would be sharp practice to rely on that to exclude claims of fraud. But if the on a proper construction, the settlement is construed as being a settlement of claims in fraud, unknown claims in fraud,
Yes.
then it seems to me there can't be a scope for a sharp practice principle of that nature, because because the parties have expressly agreed by their contractual terms that it does cover claims in fraud.
In my respectful submission, that wrongly gives no place to the operation of the subjective application as a matter of conscience of the conduct of the releasee. So your lordship is what your lordship is putting to me is the objective behaviour of the parties vis-à-vis the interpretation of the contract, and what the unconscionability principle, sharp practice principle, call it what you want, establishes is that even where, as a matter of objective interpretation, the claim is released, if one party knows of it and the other party doesn't, you're into a different category where the court is focusing on the conscience of the person who, as a matter of strict law, is entitled to rely on that release. But the court is saying, as a matter of unconscionability, I'm not going to allow you. Now, you can take some extreme examples which test that. Let's take an example of someone who settles a very weak claim, which is missing all sorts of key information, and it's only worth about £10. And the parties enter a settlement agreement, and one side sitting on knowing that there's a very substantial fraud claim, which the other party doesn't know about. They manage to get the other party, because they've concealed that information from them, to sign up to an all-encompassing wide settlement agreement, which objectively covers unknown fraud claims. There's still misconduct, objectively, on the part of the party the releasee. They are continuing to conceal their fraud from the other party. And it's a perfect fraud. It is using the court's principles to commit a perfect fraud. You use a sprat to catch a mackerel.
But if in a large organisation, let's assume a large organisation that there's been some dishonest conduct in a relationship with a contracting party. Let's say, using an example in the documents, some
Yes.
forged documents were used, forged invoices rendered, third party paid. The contracting party paid. That all comes to light. So it shows thoroughly dishonest behaviour on the part of an employee or employee of the organisation.
Yes.
And in order to settle those proceedings, there's a full and final settlement of any and all claims in fraud, known or unknown. Are you saying it's impossible in those circumstances for the organisation that has committed the known fraud to settle unknown claim frauds against it, even in the circumstances where where it knows that there either has been or may have been other fraud claims?
Not impossible, but the courts in equity have an additional part of their armoury, which is to say to the person who has entered into the settlement agreement, still deliberately concealing another fraud, which they haven't told their counterparty about it, you are at risk of the court saying it's unconscionable to allow you to rely on this.
Well, just at risk, or in fact you just can't?
Well, I don't think there's been a decided case which has actually decided precisely what the parameters are. That's a question for the trial judge, unconscionability. And on the statement of principle of Lord Justice Chadwick, you would probably say that principle should be applied.
It seems like we're abrogating the principle of freedom of contract here, aren't we? We're saying the parties, you simply cannot agree to release unknown claims in fraud.
I wouldn't go so far as to say it's abrogating freedom of contract. What I would say is it's a valuable tool by the courts to keep people honest.
It means almost every settlement agreement can be undermined and taken to trial on the basis of allegations of fraud.
No, not unless you have sufficiently credible material to plead and prove that the counterparty has
Of course,
committed
that must goes without saying.
So this isn't a floodgates position. The courts already have the tools at their disposal to deal with vexatious
Yes,
fraud
but
claims.
I think the point that's being put is that in a circumstance where you do have a settlement agreement, let's say of fraud A,
Yes, fraud A.
and on its interpretation, because we don't get here otherwise, on its interpretation it would cover unknown fraud B.
If unknown fraud B was known by the leasee and was deliberately concealed.
That's my shorthand for.
Yes.
I mean, and we're passing over all this. Whose mind is relevant for the purpose of this within a corporate organisation? Let's just.
Well, that's
I still am troubled by that, I have to say. But anyway, but let's just So my unknown fraud bit, I known to one party, not known to the other.
Yes.
You're saying, in fact, that the settlement agreement just sufficiently arguably doesn't bite. That as soon as you can actually point to fraud B,
it bites.
You're entitled to go to trial because only the trial judge can tell you whether it's unconscionable.
It bites as a matter of contract. It doesn't bite. Equity has an ability to say it should be released in circumstances where party B has not disclosed, has concealed an unknown fraud, which party A can plead and prove to the relevant standard required in order to.
But which party A, on the hypothesis I put to you, would have known that there must have, objectively speaking, have known there was a risk that an organisation that would commit fraud A might have committed fraud B.
But that's the whole point of the sharp practice principle, the unconscionability principle, is it's not just simply based on objective contractual allocation of risk within the contract itself. Yeah. And that's why, in my respectful submission, if you take the approach, well, you've just agreed to sign away your rights in this respect under the contract, that's it, game over, because you admitted to unknown fraud claims.
What you said, claims of any type, known or unknown. Exactly.
So my point is that is a statement of principle which has yet been to be fully hammered out, and it's better that it's hammered out after trial for all the reasons I've identified. But on the basis of the facts as pleaded in paragraph 79 of our reply, the principle is engaged according to the articulation of the principle by Lord Justice Chadwick and the Vice Chancellor as endorsed by the House of Lords. And your Lordship shouldn't be troubled about that as a matter of what that will mean in terms of other claims, because there are other protections in place to meet those concerns.
And 79 is just a very broad statement of that it would be unconscionable. You don't spell out why.
Well, they knew that they were sitting on.
Well, let's say who knew. Now I will drill down into it. Well, whose conscience do you actually say is engaged to make this argument good?
Well,
because all I see in paragraph 79 is a very broad assertion.
There are two different potential arguments to that. One is you have to go sufficiently high up the tree in the organisation in order to identify who within the organisation knew about this practice and knew that settlements of this type would be entered into in the circumstances alleged. There's that potential line of argument. And there's the other potential line of argument to focus on the particular knowledge known by the bank employees who were signing up to the settlement agreement itself. The third argument, which is to do with knowledge of the employees who committed the fraud as to the circumstances in which that a settlement would be entered into. And we do actually plead, from memory in our pleading, that a feature of the alleged malpractice by the bank was to use settlement agreements to hide wrongdoing. So if the employees knew that was committing this wrongdoing and that parties who had very weak bargaining power were entering into these settlement agreements in circumstances where wide releases were likely to be granted, in circumstances where their fraud was not going to be disclosed, then that may also operate as a relevant state of mind. So there are three different routes through in terms of attribution of knowledge, and the knowledge case is obviously considered in quite some detail in the libel manipulation cases, because that's where in particular the points have been focused on. But you're right to identify it's not a straightforward question. It's not yet been explored in this case because no questions were raised by my own friend in relation to that, and the judge just proceeded on the basis of that pleading. I've got ground 4. I think I probably need to go to ground 4.
Does it add anything to what you've said already?
Ground 4 is conceptually very different, so I think the short answer is I'm afraid yes, in the sense that ground 4 is to do with the question of the plea in relation to reliance. So the passages in our skeleton argument, and perhaps I should simply say that to the extent that I haven't covered anything, hopefully we'll take the written argument for shorthand. But the short point in ground 4 is that the judge wrongly treated the question of reliance as a question of construction of the settlement deed, in precluding a finding that the fraud induced the settlement deed. So what the judge basically said is, well, Mr. Sims, you've pleaded reliance, and for your lordship's reference, that the plea in that respect is set out in paragraph 101 at page 143 in the core bundle, line tab 8.
Sorry, can you give me that again?
Yes, it's paragraph 101 behind tab 8, page 143. My lord. And the judge's reasoning in relation to this, and we should probably just go back and look at the judgment on this point just to closely follow the reasoning of the judge in this respect.
Well, the paragraph 100.
101, my lord. Sorry.
Paragraph 100 of the judgment.
Oh, the judgment.
Seems to say more or less. If as a matter of construction, the settlement deed doesn't cover this claim, this point adds nothing. But if it does, then it's circular to say that the bank had represented that there were no such claims.
Yes, so my lord, there were two errors in relation to the judge's reasoning in that respect. The first was we didn't make an allegation that there was a fresh representation which induced a settlement deed. What we were relying on as per our pleading was the original false assurances made by the bank, which the plea was, and the evidence was that there's continued to be factors which led us to entering into the settlement deed. So that's error number 1. Error number 2 was that it's not a question of construction. It's a question of fact based on the principles set out in Zurich as to whether or not there is reliance in fact. There may be questions raised by a party as to whether or not, in circumstances where you've entered into a settlement deed which objectively may be said to release certain types of claim, that would make it difficult to argue for reliance. But if the court concludes that in fact the reliance plea is made out, that it was a factor which continued to operate on the Riley's mind, and a reason why they entered into the settlement deed, because it hadn't been countermanded and corrected by the bank. They may have suspicions, but have no proof. Then the fact that it's a wide-ranging release that has different wording to it is neither here nor there. It's either a question of fact, did you rely on this original representation in order to enter into the settlement deed or not. And in our respectful submission, the judge simply erred by concluding there was any relevant distinction between this case and Zurich. His reasoning seemed to be Zurich is different because there was just a straightforward Tomlin order in that case, which didn't have wide-ranging clauses in it dealing with releases. But in our respectful submission, it's not a bootstrap argument. It's very different. If there is a representation which induces you to enter into a settlement deed, you're entitled as a matter of law to invite the court to set it aside.
Will there ever again be a settlement of this sort of claim, if that's right?
Well, no, you can enter into the settlement, but if there is still a material causative fraud, as there was, for example, in Zurich.
Well, Zurich was originally a very standard personal injury case, which was settled. And after it was settled, the Zurich, as insurers of the defendant, obtained evidence of gross dishonest exaggeration by the claimant.
Yes.
Not just making heavy weather of his injuries, but clear dishonesty.
Yes.
And they bring a cause of action for deceit. And the Supreme Court had to decide was the cause of action in deceit blocked by the fact that the personal injury case had been settled in usual terms. Answer no. But what does that have to do with the present case?
Well, is it directly applicable? The principles are the same. The complaint is that an egregious fraud has been committed by the bank in this case, involving numerous misrepresentations to the Rileys, which evidence has now been uncovered to show were untrue and knowingly so, in circumstances where they procure a settlement deed without us knowing about those claims. It all comes back to the fundamental question that it doesn't matter how wide the drafting of the settlement document is. The key question is actually one of fact, as set out in Zurich. Was there reliance? Where's their continuing reliance in fact on the fraudulent misrepresentations? It's a simple question, either yes or no as a matter of fact, not coloured by any question as to the drafting of and the construction of the contract.
So how does somebody in the position of a bank or a large organisation sufficiently address its conscience in order to reach a full and final settlement with somebody who's making claims against it? Does it have to actually investigate internally and disclose all potential wrongdoing that might subsequently be alleged against it in order to reach a full and final settlement? It can't be just reopened and by somebody who wants to go to trial to allege a lack of conscience.
Well, that's an interesting question. Is it the bank knows? So if the bank knows about a fraud which it's entering into a settlement deed with the customer, it doesn't disclose.
You see, I've been banging on about what you mean when you say the bank knows.
Okay, well,
the point is, in a large organisation, and any number of people, including people who've left the bank's employ, may have dealt at some point with the person who's brought a claim against them, or the organisation. In order to make a full and final settlement stick, the bank has to do what? Investigate internally all prior relationships, statements made, etc., with the particular counterparty, and then disclose them and say, well, we haven't acted badly, but just so you know, there may be this, there may be that, maybe the other, just so you know.
Well, if the bank hasn't acted improperly or doesn't know of any improper conduct,
no, let's
assume that there is some improper conduct that falls to be disclosed.
Yeah.
Then what is wrong as a matter of English law in the bank being potentially vulnerable to someone saying, well, I was procured to enter into this settlement deed by reason of wrongdoing. They may fail as a matter of fact.
Well, because the trouble is then, in a sense, how does it play out? In order to, somebody who's been guilty of an organisation, some part of which has been guilty of some wrongdoing, can't enter into a full and final settlement without investigating all its other wrongdoing and making full disclosure first. How does it then play out in the negotiation?
Well, I wouldn't necessarily go so far as to say it has to investigate all its other wrongdoing. That may not apply. But large organisations, if they have been involved in fraudulent conduct which has not been disclosed, there is nothing wrong as a matter of principle, as a matter of law, in the court concluding that may potentially leave them vulnerable to the charge, that has had a causative impact on them.
I mean, no, I understand that if you're dealing with an employee, for example, of the BCCI type,
Yes.
who is simply signing a bog standard end of employment clause, which has no indication that there's anything untoward at all. Where you're dealing with somebody who has made allegations of fraud or tantamount to fraud, and clearly doesn't trust you further than they can spit.
Well then I think your lordship's response sounds to me like it's suggesting that you would be rejecting summarily any question of reliance. I mean, that is the conventional way to deal with these points. Is if there's then no real prospect of actually someone showing reliance, then the court can dispose of it that way. And what you don't do is dispose of it on the basis of suggesting a bootstrap argument, which is just wrong as a matter of principle.
So can I just make sure I've understood this? The structure here, you're saying, is that what a party to settlement can say is that when I enter the settlement in which I agreed to settle unknown claims in fraud, I did that based upon my reliance on certain representations which were fraudulent, and so I was deceived into agreeing that I would agree to release claims in fraud.
And so ultimately the question of fact, did that party actually subjectively rely on that or not? Or will they be cross-examined, for example, say, well, hang on a second, you signed up to this settlement document which said X. How can you possibly say you relied on it? And that would be a question of fact for that witness to address. Or for a party to strike out on the basis that reliance is hopeless.
This doesn't seem to be very different from the sharp practice principle.
There's a debate, I think, isn't there, by Lord Hoffman in the House of Lords as to potentially different juridical bases. So
yes.
there may be some overlap with the concepts.
Yes.
But I think it is a different concept in the sense that you are seeking to set aside as a matter of misrepresentation rather than saying equity will not allow the person who gained the benefit of the release to rely on the...
When you are agreeing to not that you will release unknown claims from fraud, you are at that point saying, I may have been deceived, but notwithstanding that, I release that claim. So how can it survive?
Well, you're saying objectively that's how the court has interpreted the contract, which is a different question.
But it is what the parties agreed.
What the parties agreed, but it remains open for a party to say, notwithstanding the fact that objectively I'm treated as bound to this contract, I did, as a matter of fact, still rely on the fact the bank had told me it was intending to support me and return me, and even though I had all these doubts about it.
Hang on, my Lord's point is, you have contractually acknowledged that there may be claims in dishonesty of which you are not aware. That is what you are contractually acknowledging and agreeing. How can you then turn around and say, but I relied upon the fact that there were no claims
well,
which are in fraud or whatever that I didn't know about.
Well, I think what the point your lordship is making is a slightly different point, which has not been pleaded against this, was there was some sort of contractual estoppel. And the point was not disposed of us on the basis of a contractual estoppel.
No, I thought I thought I was actually just, in a sense, picking up.
I think I probably
with it rather than inventing a new
one.
Oh,
well. My short point is this: that it doesn't matter if it does not follow simply because objectively the court says we are treating you objectively as having agreed to X, that precludes from a party saying it was a causative factor which caused me to enter into this settlement deed. That's the point, simply put, and that's what you get out of Zurich, even if you're suspicious. And the idea, as per His Honour Judge Matthews in Hoskins, that this is a bootstrap argument, in my respect for submission, is it's just wrong as a matter of legal analysis. The key question is one of factual reliance. And so the judge erred in concluding that could be summarily disposed of us, because Millennium Friend avowedly pursued his application on the basis of taking the facts as stated by my client. He did not advance his case on the basis of some other freestanding real prospect of trying to get the judge to reject my client's evidence or the evidence pleaded out.
And you're relying on what, an implicit statement that there is no other cause of action? Is that the statement you're relying? What's the statement you're relying upon for this purpose?
No. The original representations.
That what we are acting in your best interests rather than acting as a bunch of thieves.
That we're going to support you and return you to mainstream. We will support you in this turnaround, and the continued insistence by the bank that actually all these things you complain are untrue. The bank, even now, still in its pleaded case, is contending it did support us.
Yes.
What? It's joining issue with us on all of that.
Yes.
And if we manage to show at trial that Messrs. Smith and others were lying to us about that, and if the court accepts at trial that we did in fact continue to rely on that and their continued protestations in relation to that, then reliance is made out. But of course, there's a long way to go in relation to all those points, but it's not the way the judge disposed of the point against my clients, or in my respect for submission, is an accurate analysis as a matter of law. I'm conscious of the fact I've taken more time than I've indicated.
Well, you have rather, but we've been asking a lot of questions.
I'll just check.
I think you've covered the ground. We should ask Mr. Verger whether he has anything to
Yes,
add.
it's actually Mr. Ramel who's been a last-minute substitute for Mr. Verger.
I'm so sorry.
So, I'm grateful.
Well, nothing from me,
Thank you very much. Mr. Sims, we'd like you to follow the same order as... sorry. Mr. Sinclair,
Yes.
we'd like you to follow the same order as Mr. Sims,
Yes.
and start with ground 5, please.
Yes, certainly. My lords, my intention had been to, but I'm obviously in your lordship's hands, to begin by looking at the pleadings and the borrower correspondence, because it has some bearing on the arguments on the various grounds and on limitation. But I'm happy to deal with ground 5 in isolation first, if you'd rather. I'm in your lordship's hands.
Anything you need to tell us to deal with ground 5, then do. I mean, we have seen the letters.
Yes.
But I won't say more than if you could start with ground 5, that would be very helpful.
Well, I'll go straight to ground 5
Yes.
and pick up the other points later. So yes, ground 5, your lordships are aware of the argument. We say prima facie it's not a promising argument, just looking at the terms of the settlement deed, which seems to be the logical place to start. So, my lords, if you can go back to that, which is in core bundle 11 at page 275. So, as your lordships know, the assignee of the claim is Mr. Riley, and he is the claimant. If you look at the heading for this claim, it is just Mr. Riley and his wife bringing her own claim, but there's no suggestion that it's RHL is in any sense a party to the proceedings. And if one then looks at clause 7, which is headed covenant not to sue and releases, so it has a twin nature, twin track. 7.1 is the release and 7.2 is the covenant not to sue. We submit that on its face, clause 7.1, just looking at that on its own, is clearly drafted in such a way as to exclude claims which arise in connection with Riley Holdings. Picking up one of the points that my Lord Snowden, or Justice Snowden made about whether the relevance or otherwise of the hereby releases wording. We say a few things about that. I mean, firstly, my Lord, the word hereby in my submission means no more, no less than by this document. That's what it means. Hereby releases means, or by this clause, that is the way we release it. It doesn't say anything about from this, it doesn't have a temporal meaning to it.
In a sense, every agreement is hereby.
By the, yeah, indeed.
Right now.
Unnecessary.
We agree.
Well, I don't think it means, well, what I'm trying to say is I don't think it means right now. It means by this document.
Yes.
Although, I mean, it actually could have a temporal meaning, because it is possible that you can have, for example, you can agree to release to take effect in the future.
You could agree.
I mean, and this does say hereby releases and forever discharges, which clearly does have some temporal meaning.
Well,
I mean, it's
yes.
you know, I mean, as you say, the clause has two, hereby releases and forever discharges, so there is some attempt to have a temporal.
Yes, my lord. So, in fact,
I'll take your point. But
yes. Well, I was just focusing at the moment on the word hereby, but more generally.
Do in context, please.
In context, my lord, indeed. But more generally, clause 7.1 does the operative words. There are three of them in our submission. So the first one, in fact, is in the terms of this deed are in full and final settlement of. That's the first thing it does. And then it does another thing, and each borrower hereby releases. And then it does a third thing, and forever discharges. So the clause is doing all three things, one on top of another. And if you go to the, if you look at the wording in the Kazimimi and Siddiqui case, the operative wording there was just in full and final settlement. And that was sufficient as a matter of principle to release future claims, albeit as a matter of wording, it didn't release the particular ones on analysis. But so in our submission, the clause, the operative words of the clause are sufficient to cover future claims, and that's clear from the rest of the clause, which says any claims that it may have.
We're not dealing here with future claims. We're dealing with current claims vested. Sorry, I don't know. Yes, you're dealing with ground 5. Current claims, yes, which exist in law, vested in somebody else. I mean, the key question, I think, as we happened upon this morning, seems to be not whether, when signed, this document could release and discharge a claim which was then vested in RHL under the control of the administrators, but whether it would have that effect when the claim was subsequently acquired by Mr. Riley.
Yes.
I think that's the target, isn't it? That I mean, it certainly is one of, if not the central target you've got to aim for.
Yes, my lord. Yes, and that's right. I'm grateful. So it's it's not really a future claim, as you say. It's a claim that's existing at the moment, but in the hands of someone else. But that in the future will become a claim that Mr. Riley can bring.
Correct.
And in our submission, clause 7.1 is wide enough to cover that because it talks about any claim that it may have or hereafter can, shall, or may have. So the use of the words hereafter there means that it's not a claim that it currently has, but that it hereafter has. And that, in our submission, is squarely aiming at just this sort of scenario where the Mr. or Mrs. Riley do not currently have a claim, but in the future they do acquire a claim. And that is wide enough, we would submit, to cover an assigned claim. My learned friend attempts to draw a comparison with a cause of action post-dating the settlement agreement, which was discussed in an issue which arose in Maranello, as your lordships will be aware, that some of the claims predated the settlement and some post-dated the settlement. And in their skeleton at paragraph 32, they refer to the claim here as being, quote, a fresh claim arising from a future event which had yet to occur. And they call it a cause of action which did not arise until after the date of entry into the settlement deed. But in our submission, that is not a true equivalence. On the one hand, you have causes of action that arise from events occurring post-settlement.
I mean, but wait a minute. You're not saying, are you, that a claim which might subsequently arise or might subsequently become known to law wouldn't be caused by this?
I'm not saying that. I'm not saying that, but I don't need to get into that discussion.
No, but you're not saying that these words would have no meaning apart from to cover assigned claims.
No. So if there was a change in the law that banks owned a retrospective duty to do something, then that would be a new claim that has arisen.
Yeah, or a new cause of action was suddenly developed by a court, which wasn't previously understood.
Yes, a BCCI and alley situation. Yeah. Then this wording is wide enough to cover that. But I don't even need that because this is not that scenario. This is a pre-existing cause of action, which was a complete cause of action in the hands of RHL, albeit it was the standing to bring that claim was transferred after the date of settlement.
Yeah. But if you wanted to cover, why didn't the bank, if you wanted to exclude the possibility of such a claim being brought, why wasn't RHL by its administrators made parties to this agreement?
We have no evidence on that question, my lord, but it's an objective question, isn't it? So a reasonable bystander might take a view.
Reasonable bystander who had observed the parties,
negotiation,
knowing how the origins of this agreement, where there was no reference. The point you've got to meet, I think, is that knowing how the parties had come to enter into this settlement agreement with on the one side claims being made about the conduct of the bank in relation to its customer RHL, and RHL having gone into administration at the behest of the bank. If you wanted to close off claims by RHL, in whosever hands they might be, why didn't you? Why wasn't RHL's administrators a party? And would the objective bystander say, well, it's because it's not intended to apply to such claims?
Well, the objective bystander, clearly, no one is saying that this clause prevents RHL bringing the RHL claims.
Right. Or indeed anyone other than Mr. and Mrs. Riley.
Indeed, that as well. Exactly, that is true as well. So, and indeed the administrators, for example. So the bank, what the objective bystander would say, well, clearly the bank. I'm not giving evidence. This is just what an objective bystander might think. The bank would say that we think the risk of the administrator bringing this claim is sufficiently low that we're not worried about it. Here we're negotiating with the Rileys. we want to close off all further claims from the Rileys while they're in the room. We're negotiating with them. We never want to see them again, in a sense. That is the point.
You do want to see them again. You want to see them making the payments to you.
We want to see them sending the payments, but
what
that's
you don't
it.
want is them to be to turn around in 12 years' time and say, not only are we not going to pay you anymore, but we want our money back.
Yes. So all we want is the Rileys to send a cheque every how often to pay the settlement sum. But apart from that, we're trying to draw a line under the relationship completely with the Rileys. This is the objective bystander's interpretation. And so that they may not bring any claim that they currently have, but also any claim that they acquire in the future, so long as it falls within the subject matter requirement. So if one had a Kazimi Siddiqui situation where their next door neighbour says, oh, I've got a very similar claim against the bank actually, and you're experts at all this now, so I'll assign it to you, then they can bring that claim because that doesn't fall within the subject matter release.
I'm not sure that's exact. With Siddiqui, there were claims that were arising out of the tripartite agreement.
There were tripartite, but there were also some separate claims as well.
Yes,
so there were some.
But I don't think you can entirely distinguish Kazmi or whatever it's Siddiqui on that basis, because there were some undoubtedly connected claims.
No, I can see that, and I'll come back in a bit more detail to that case. But all I'm saying is that if they had taken assignment of a totally different, unconnected claim that falls outside the subject matter description, then they're fine. But if they take assignment of a claim that's within the subject matter description, then they're barred. And that is a perfectly commercial thing for the bank to do, to say that the Rileys are the people who've instructed solicitors to write aggressive letters. They're the ones who are most likely to be pursuing them. And they want to get rid of them. That is perfectly, in our submission, a commercial reading of this. And so this is not a new cause of action, as my learned friends suggest. But and my lord,
I'm not sure that point was pursued orally.
I think I heard it, but I may be wrong.
I didn't press. I think the point made, the timing point in Maranello, from memory. I don't think I developed that point. And
This is not the same situation as that.
It's not the same situation as that. I think the passage I referred to was just the objective point about assignment of cause of action. That's the only relevant step after the event in this case. If the pre-existing cause of action existed, the only relevant step was the assignment. I'm not sure if that assists.
So, thank you. That's clause 7.1, but we have 7.2 as well. And in our submission, it couldn't be clearer that 7.2, my learned friend addressed 7.2, but only to say, to address my argument about how wide the subject matter of it is, which in our submission is very wide, because it's not just the release claims, which are themselves wide, but it's any claim in any way connected with the release claim. So it's a double layer of width. But that wasn't really the point that I was making, which is that clause 7.2, or I think one of your lordships made to my learned friend, which is that clause 7.2 says the borrowers agree that they will not bring or commence any proceedings whatsoever against the bank, ... And so Mr. Riley is bringing a claim against the bank. That is what he's doing. So it doesn't say anything about whether that's an assigned claim or not. It's just Mr. Riley will not bring any claim that fits within the subject matter limitation set out there. And so that, in our submission, answers any quibbles over the wording of 7.1, any difficulties about future claims, assigned claims. It's just a blanket.
But it still has to be connected with the released claims.
Yes.
And if the released, the argument against you is that the released claims just didn't include any cause of action vested in RHL.
But my lord, we would say that the definition of release claims is a subject matter. What is the claim about, rather than who has the cause of action? So what is the factual basis of the claim is the subject matter. And so we would say this is a claim arising out of or in connection with Riley Holdings. which is, and therefore is a quote-unquote released claim, and therefore a fortiori falls within 7.2 because it's not just a released claim, it's connected, in any way connected with a released claim. So I suppose if one took a very strict, well, I don't think one can read it, but if one misread clause 7.1 to say that, it doesn't cover assigned claims owned by RHL, well, 7.2 would cover that, because this would be a claim that was in any way connected with that sort of claim. But
with a claim that isn't within 7.1. I mean, it just seems slightly odd that you're saying that if a claim doesn't fall within 7.1, that it could fall within 7.2. In circumstances where 7.2 refers back to the released claims. I'm struggling to understand where you get the expansion.
It's only because 7.2, one could imagine something that is almost a released claim, but is not a released claim for some reason. But 7.2 says that you can't bring a claim which is arising out of or in any way connected with the released claims. And so we would suggest that that is an expansion on a released claim. I don't think we need to go that far here, but that was the point I made below. But that's not really the reason I rely on 7.2 here. I'm relying on the first few words, that the borrowers agree they will not bring or commence any proceedings. And that, in our submission, must cover any claim where the claimant is Mr. Riley, so long as it fits within the subject matter definition.
But because 7.2 is, you've got to work out, you've got to interpret 7.1 to be able to understand the 7.2, haven't you?
Yes.
So if it is the case that the release claims do not include the assigned claim,
Yes.
then you've got to rely on your expansive interpretation. And if it does, then you don't need 7.2.
Correct. Yes, my lord. And in our submission, the parties obviously had in mind the RHL claims to the extent that if I didn't take your lordship to the Nabarro Conference, I will at some point, but you've seen it in broad outline. It refers to all sorts of claims that really RHL only can bring, such as the swap mis-selling claim is only really sensibly an RHL claim, and I think my learned friend, broadly speaking, accepted that RHL was
the
the
Nabarro letters are very clearly written repeatedly on the basis of our clients are the Mr. and Mrs. Riley and NDA.
Yes.
I mean, they don't purport to threaten proceedings in right of a cause of action possessed by RHL, and they couldn't.
No, I accept that. Yes, that's true. So they're not purporting to say we're going to bring a claim on behalf of RHL itself, but they are making all sorts of allegations about wrongdoing allegedly suffered by RHL and causes of action that, on analysis, really are only RHL's actions. And so when it comes to settling them, the parties are the objective bystanders looks at those documents and looks at the clauses 7.1 and 2 and says to him or herself they're trying to cover off to the extent they can, with the Rileys only being the people in the room, they're covering off all those sorts of the claims that were being discussed in the Nabarro correspondence, including claims that really, on any proper view, are only RHL claims.
When you take us to the Nabarro's letter, you better identify those.
Yes, I will. So can we just, I don't know what time your lordship.
Would you like just to finish off the settlement deed, and if you need to look at the assignment then do that as well. And shall we leave that correspondence for tomorrow?
Yes. So the only other question was whether to look at this Kazimi case, but we could leave that as well. I don't mind.
I think we've done a good day's work in the heat. So
Yes.
we'll go back to Kazimi tomorrow.
Very grateful. And my lords, just to be clear, we're definitely finishing tomorrow, are we?
Yes.
But there's no. Yeah.
Yes. We are definitely going to.
Well done, Hugh. Speed up.